This is Bruce Wall from the City of Scottsdale's Neighborhood College Program. We're all in this together.
The City of Peoria. We're in this together.
The City of Chandler. We're in this together.
Hi, this is Jamie from the City of Scottsdale with my daughter Jocelyn. We're in this together.
City of Tempe. We are in this together.
Happy holidays, happy Hanukkah, Merry Christmas, Happy New Year. We're going to be covering all of those today. Just wanted to say welcome to our fall 2021 HOA Condo Academy class number 12. I have a little special visitor with me here today that I'm going to show you. You really? Don't you love live TV? I had to bring my little buddy here today for a holiday visit. And we're having the exterminator at our house today, so I couldn't leave her at home. So hopefully she'll be good. I'm going to give her to Morgan, who's in my office, who probably has never held a dog before. So I'm sure that'll be a problem. Anyways, welcome to our fall 2021 Virtual HOA Condo Academy class number 12. We're doing a double header today, meaning that we're covering our first Fridays for our firm for December 2021. And we're also having our fall 2021 Virtual HOA Condo Academy. So the topic of our classes today is going to be question and answers. I asked you to bring your questions, big and small, and the class won't end until we answer them all. It's great to be here with you today. My name is Beth Mulcahy, and I'm managing partner and senior attorney of the Mulcahy Law Firm in Phoenix, Arizona. I've enjoyed working with associations for the past 25 years. Can't believe it's been that long, although sometimes I look in the mirror and I think, yes, it has been that long. Anyways, our firm currently represents over 1,000 associations throughout the state of Arizona. I've dedicated my entire career to working with associations, and that's one of the reasons why we offer these free classes through the Virtual HOA Academy and also the First Fridays free call-in, because we want you to have information at your fingertips so that you can be better board members, make good decisions for your community, better managers. You can help manage communities to be their best. And also for the homeowners that are in the audience today. This is also for you. For some of you who may have listened to some of my other seminars in the past, not only do I represent HOAs and condos as an attorney for them, but I've served on my board, and I also had, a pretty good stretch where I was a disgruntled owner at my association. So I understand what it's like to be frustrated with your board. And so if you're a homeowner that's listening into these classes, know that we understand that when you come to us and you say, hey, there's a problem with my board, we want to help too. We want your board to function effectively. So we're here to answer questions for you too. So you can take the information back to your board, or maybe even determine if you want to run for the board, or maybe you may need to move if it's such a dysfunctional situation. So anyways, so that's the purpose of our classes, just to help you. And also the purpose of this free Fridays is to answer your questions, because some of you may not have a legal budget to do that, or some of you may not have your board's support to do that. So that's why we prepare for these classes and provide this free question time for you. Okay, so first question we have is from a board member. He wants me to assume we do a reserve study every 3 years and the reserve fund is 95% funded. Just a comment from me. Great job. That's excellent. We want to add on to the pool house. The pool house is a reserve item. Can we use reserve funds to do it, or do we have to use operating funds and then after the next reserve study, use reserve funds to maintain it? If not, how can we fund it? Okay, really great question. So because this is an area that's a common area facility, and the association is maintaining it just like they would maintain a clubhouse, the pool house is pretty similarly situated. I do think that this is a reserve item and you could use reserve funds to fund it. What you may want to do is double check as to, is your pool house in your reserve study? It should be. My opinion on that is that the reserve funds could be used for that purpose. We have 2 great cheat sheets that might be helpful to you as you navigate this process. You can find those on our website at mulcahylawfirm.com. The first cheat sheet is our cheat sheet on reserve funds for community associations that has just a great dialed in 411 on everything you need to know about use of reserve funds and reserve studies in Arizona. And then we also have a cheat sheet on budgeting because if you're budgeting for a project like that, you may need to add that to your line item budget as a reserve item. Great question. Our next question is from a board member. One of our homeowners has multiple enforcement violations that have not been consistently applied by us. For example, landscape and parking on his lot against the CC&Rs. We adopted a fine policy in 2017. Our problem is that the homeowner sends multiple emails asking questions and slips through the cracks. He has never formally appealed the violations. Recently, we have started to be consistent with our biweekly inspections and enforcement policy. This homeowner is now on a step 5 of our collections process. His story now is that the HOA doesn't have any authority to tell him what to do with his property. What do you suggest? Okay, this is what I would call the slippery homeowner syndrome, right? Where we have a homeowner who is kind of used to working this system. So there's violations on their lot and they, instead of focusing on just fixing the landscaping or parking the vehicle in the way that they're supposed to be parking it under the documents, they start pointing fingers and say, well, this lot has this violation, and they start doing records requests. And, maybe they start thinking of legal defenses as to why they don't have to do it now. Those really are not going to work in this situation because landscaping is something that is changing every day, right? It's growing, it's getting worse. And so that's kind of a violation that they wouldn't be able to say that we waived our right to enforce it. Same thing with parking, because parking happens usually frequently. They're changing their parking position almost every day. So I don't think this person has any grounds to stand on, but I'd be careful with a person like this because they're sometimes a little bit tricky to deal with. So what I'd like you to do is take a look at our cheat sheet on enforcement of governing documents, and it kind of gives you a really good overview of the legal process and the legal options that you have as you navigate, the violation with the homeowner. A couple of suggestions that I have for you would be you may want to turn this one over to the association's attorney once you get through the 5th step of your collections process, because it doesn't seem like this person is going to comply. And, there's a bunch of different options that you have. The lawyer can send a letter to the homeowner. You can go to the Arizona Department of Real Estate, file a complaint against the owner, and have an administrative law judge hear the issue. We can go to Superior Court and have a judge order that the owner takes certain actions. I mean, of course, we don't want to take all those, steps because they cost money. But if this owner truly doesn't want to do what they're supposed to do, that may be the only way to get the owner to comply. And also, we can give them a pretty good pushback on, we don't have authority to tell him what to do, and he's trying to claim waiver latches arguments that we didn't enforce it in a timely manner. We'll be able to push back really well with good legal arguments that show the owner that they're wrong and that they really just need to do what they're supposed to do under the documents. Okay, next question is from a board member. Can we fine flippers $500 for failure to register with our office? They do sign paperwork at closing, and we put a notice on their door. Okay, so flipper syndrome, right? Where we have people coming in, purchasing a lot or unit in your association. They will fix it up quickly and turn around and sell it. So I'm not exactly sure why they would need to register with your office unless it's like you're thinking that it's a rental. I'm not sure. I probably would need a little clarification on that. But really, you can only fine someone, an owner in your association, for violations of the CC&Rs, bylaws, or rules. So I would have to look at, what exactly the violation is that you feel that the flipper is doing. And if it is in fact a violation, you certainly can fine the owner after notice of the violation and an opportunity to be heard. And a couple thoughts are, if this is like a rental issue, if that's what you mean by failing to register with your office, there are specific amounts that are chargeable under Arizona law that we can only charge renters for their owners who rent their property for failure to register. So you want to be really careful on that. So you, as a board member, you may want to have your board reach out to me And we can go over, what type of fine you can have against the owner based upon the violation. But if you're fining the owner for failing to register a rental, be really careful on that, because we can only charge $25 for the paperwork, for them failing to turn in the paperwork regarding a renter, and then a small late fee of $15 for failing to do that if they, in fact, don't fill it out. Okay, the next question. Our board would like to adopt a pass-through policy, which currently we do not have. Please explain the pass-through provision, and does it require approval of 2/3 majority of the members? Sometimes it's hard when I can't ask follow-up questions. That's the worst part of having this job. So, maybe this person who asked this question, if you could just kind of send me a clarification, and then I'll pick up this question and answer it at the end. I don't know what you mean by a pass-through policy. You have to explain to me a little bit more what you mean by that. Okay, next question. Our bylaws state the following. The board shall have the following powers and responsibilities. 1, to adopt and publish rules. 2, to exercise for the corporation all powers, duties, and authorities, except for the powers that are reserved to the members. Does this give the board the authority to set up, publish, and enforce rules and a fine schedule for violation of our documents? So yes, it does. And we have a really great cheat sheet on board members' roles and responsibilities that would be helpful for you in terms of what your board can and can't do. So I would encourage you to look at that because I think that will be really helpful to you. But the bylaws clearly state that you can, pass rules and regulations, and state law allows you to fine under the Condominium Act and the Planned Communities Act. So you have the right, although it's not an obligation, to create a fine policy for your community. Just a point of caution, if you do create a fine policy for your community, be sure to run that by your legal counsel, because you want to make sure it's consistent with Arizona law. So if you're going to be fining somebody, you want to make sure that you're following what the fine statutes say under the Condominium Act and the Planned Communities Act. Okay, next question. If the membership votes to get rid of an existing roofing reserve fund, can the board distribute the money already in the fund back to the homeowners equally, or can the board transfer it to a painting reserve fund? This is a hard question. So I don't know how these funds were set up for your community. So, did you fund these items through a special assessment for, roofing? If you did, that money would be allocated to roofing. If you didn't, and it's just, you just pour money into your reserve fund, and the board then determines how that money is spent, there's a possibility that, you might be able to move it to the painting reserve fund. So I'd really need to know more before I could give a definitive answer, but be really careful if the homeowners, paid into the roofing fund and they expect it to be used for roofing. If you're switching that back to the, the owners are taking care of the roofing, the owners in your community are going to be really mad if they feel that that money, should be refunded to them and it's not being. So if you're not going to refund it, you definitely want to get your lawyer to sign off on that, number one. And then number two, you're going to want to communicate to the owners what you're doing and why, and the legal justification for it. Don't just switch it, to the painting fund without talking about it at a board meeting and having sign off from your legal counsel. Okay, I already talked a little bit about the reserve fund, but we remember that we have that cheat sheet for you. You might want to take a look at that, when you are thinking about things that you need to do in your reserve fund. Okay, the next question is, our association consists of multi-level condominium units. We recently had a small fire contained within one unit. It caused no damage to the outside of the unit, but it raises the concern that the adjoining units and common areas were at potential risk. Do we have the right to request a certificate of insurance from an owner? Our CC&Rs state that all owners are to name the association as an additional insured on their policy and to provide the certificate of insurance annually, but this has never been enforced. Can we request that from a specific owner, or must we enforce it universally? So great question. This is like one of the more advanced, harder questions. And I'm glad I've been around for a while and I can answer it for you. So fires, water damage in associations, especially condominiums, are really tragic. A, it's horrible for the owner to live through, and B, sometimes it affects neighboring units, and that's a serious inconvenience. But there's also a financial side to it, in that if the owner that has the damage in their unit, whether it be fire or water, and honestly both are equally bad, if they don't carry insurance, or if their insurance company denies coverage for some reason, it really puts the association and the neighboring owners who may have damage in a very difficult position. So, you have in your CC&Rs that, owners have to provide a certificate of insurance annually. And you indicated that you haven't been doing that. Please start doing that in 2022. And you most definitely can request that from a specific owner right now. You don't have to enforce it universally, because that owner had the fire damage in their unit. And I think you really do need to know if they have insurance coverage, and they need to provide you with that certificate of insurance. Also, I would reach out to them to find out what are your plans for renovations or repairs now that the fire damage has hopefully been cleared up a little bit, stabilized. Are they going to come in and totally renovate the unit, and open the dialogue on that so there's no misunderstandings? Okay, next question from one of my favorite management company representatives. I have a tenant in a community that was growing marijuana on their patio. Ooh, this is a good question. The tenant is now claiming the roofers, when redoing the foam roof, killed their marijuana plants and want to be refunded the cost of the plants and the marijuana they made. Wow. Morgan and I are here. We're doing First Fridays, and this is a first for sure. I can hear her chuckling. Okay, the HOA had no prior knowledge of the marijuana plants. There was no architectural submittal for the plants. Does marijuana for personal consumption need to be grown inside the condo, locked away from minors potentially accessing it? Okay, this is going to be a really good class because we've got some great questions. Okay, don't forget that during the 2020 general election, Prop 207 legalized and governed the adult use regulation and taxation of recreational marijuana. Remember, on November 30th, 2020, the Arizona Secretary of State certified the voters' approval of the proposition, and it became the Smart and Safe Arizona Act. So obviously, we've had some legalization of marijuana that just kind of went into effect towards, the end of 2020. We honestly haven't had a lot of questions on secondhand smoke from marijuana, but this is the first on growing marijuana. I have had a case many years ago where it was a smell nuisance, and there was a problem with the smell, and we were getting a lot of complaints. And so there was a water leak actually. And then we went into the unit and we found out what the smell was. The owner had dumped like literally a ton in terms of weight of dog food in their unit to cover up the smell of the growing marijuana that they were doing. And the drip system that they had installed had malfunctioned and flooded. So that was a very interesting case. Of course, that was pre-Prop 207. Anyways, back on track. So there's a lot of issues here. I feel like I'm taking the bar exam. Okay, let's start with number one. Can they be refunded the cost of the plants and the marijuana they made? Very unlikely. I can't imagine that the foam roofing did cause that damage. They should have, I'm sure there was notice given to them. And if they had something that was valuable on their deck, they should have removed it. Also, they really shouldn't be growing something like that, that could be consumed by somebody who's underage, whatever. It's just a bad idea altogether. So I would, let them know that they really shouldn't be growing that on their limited common element in the future if they plan to do that. I guess a couple thoughts on, and if they do have a claim, it would be against the roofer. So we're not going to get involved in that, but I don't even think that there is a claim on that. I'd have to find out more information, but at first glance, no, I don't think there's a claim. So can we require them to grow it inside their unit? Yes, I think that we should if they're planning to do that, I think we should, tell them if it's just for personal consumption, it really does need to be inside the unit. If they're growing it, a large quantity of it, we might be able to argue that, they, if this is like a manufacturing plant for pot or something, that's not going to be okay because there's going to be business problems on that based upon, usually you don't allow business to be run within a condo or a planned community, like on the property. But that would just be for large amounts. Morgan is such a superstar. She just looked up for me that the act that the Arizona state legislature, and the governor signed off on after Prop 207 vote says that individuals can consume and grow a limited amount of marijuana within a private residence. But if it's impacting somebody else, that it would definitely be something that we would be able to regulate. So short answer would be, it appears that under the act, that was signed at the end of 2020, that they can consume and grow a limited amount of marijuana within a private residence. But I would argue that it's not safe to have that on a limited common element where anybody could just have access to it. So they should be growing it inside. They're probably going to say we need certain type of lighting, because I remember from my dog food case that there was also a really extensive blue light system within the unit. And so they may need to find a way to do that inside, but it is possible. Okay, next question from a board member. Regarding submission of ballots for elections and referendums by email. Your technology cheat sheet recommends that members scan and email their paper ballot to a designated email address. However, can an HOA simply embed the ballot in the email message, give the members the option to check off choices in a reply email, and as a signature, type their name to specifically confirm that they consent to the submission of a ballot by email? To be accepted, ballots would have to come from an email address known to belong to the member. The statute seems to cover this, but it's kind of difficult to comprehend. Okay, so you're one of those tech-savvy associations that I love. When I came up with the workaround of snapping a photo of the ballot and allowing owners to return it to the association by email, that's the low-tech solution, right? So that can be done, but also the solution that you're talking about most certainly can be done. Remember, under the law, electronic voting is permissible so long as the association uses a platform that satisfies a number of requirements. There's 4, and I'm going to go over them real quickly. Number 1, it has to be unique to the person using it. It's capable of verification. It's under the sole control of the person using it, and it's linked to an electronic record to which it related in such a manner that if the record was changed, excuse my phone, the e-signature would be invalidated. Just one thing that you might want to know is that there are several companies that provide e-voting services so that your association wouldn't have to, handle this entire process electronically. We've had a number of annual meetings and removal meetings where they hire these electronic voting companies to come in and do everything. It's not super expensive. Depending on the size of your association, it might really help you. And if you want the names of those companies, just reach out to me by email at bmulcahy@mulcahylawfirm.com, and I'd be happy to provide them to you. We also have a great blog on this topic called Online Voting for HOAs and Condos. If you're joining us on Facebook Live, you can also find that on our website, mulcahylawfirm.com, under the blog section. Okay, finally, a question from an owner. Glad we've got some owners here today too. Records requests. If an owner requests to review records, can they charge the homeowner 15 cents to print the records? The homeowner has not requested copies. How do we handle records that are available electronically only? Okay, so great question. So under the Planned Communities Act and the Condominium Act, associations do need to make their association's records available to the membership for inspection. And we can charge 15 cents a page if they want a copy of the records. So the question is, if you just want to see the record, but you don't want to pay the 15 cents, can we just ask to see the record? Yes, of course you can do that. The statute allows for that. Just make sure that you're not requesting a record that can't be reviewed. An example of a record that under the law owners are not allowed to see would be like executive session minutes, advice from your attorney, the names of delinquent owners, personal information about owners like their email or their cell phone number. But pretty much everything else is fair game. So we have a great cheat sheet on this topic called Community Associations Records and Documents that would be helpful for you. So how do you handle this? It's kind of a sticky wicket with the pandemic still going on in our country and around the world. So some management companies aren't allowing owners to come into their conference rooms to review records. So I don't quite know how your management company, or even if you have a management company, is handling that. But, my advice to associations right now is if you can pop somebody a record that they want to see by email, just do it. Don't charge the 15 cents. Just get it to them quickly. We're not hiding anything. We want the owners to have the information at their fingertips so that they feel comfortable about how the association's business is being run. And so I really recommend that make it easy for the homeowners. We do that all the time. The only exception would be if the owner wants to review like thousands of records. If that's the case, we're not doing that. That's going to be too onerous for the computer systems and the drop boxes. So we may have to set that person up in a conference room somewhere to look at those records. If you're a management company that's listening and you're not allowing owners to come into your business right now during the pandemic, our firm would be happy to have the owner come to our office, and we'll set them up in a conference room and review the records there. So just let us know, and we can do that. Okay, next question is from a board member. We feel the need to amend one article in our CC&R documents. It reads as follows. A 55 plus owner can have a relative, 21 plus, also occupy the residence. We now have 55 plus parents that want their 21-year-old kids or grandkids to be allowed to live here. We wish to change the age to no one under 45 can live in this 55 plus community. We wish to maintain our senior community status. How do we go about doing this amendment to our documents? We have more than enough residents here willing to sign this change to make over 66 and 2/3 of the owners would have to approve it, you're saying. They want it done quickly before we have more issues with sales. Okay, so we have a great cheat sheet on this topic called Amending Association Documents, a 5-step plan on our cheat sheet tab of our website at mulcahylawfirm.com. Okay, so there's a lot of issues going on here that I want to talk about. Number one would be the procedure to amend your documents. Check out our cheat sheet to do that. Check your amendment provision in your CC&Rs to make sure that you're doing it properly. I would definitely get your association's attorney involved in writing up this amendment because it's going to be a tricky one to write. So under the Fair Housing Act, there's an exception where associations can discriminate with families with children if they're designated as a 55 and over community. And so there are certain requirements that need to be met in at least 80% of the lots or units in your association. At least one person who's age 55 or over must reside. So that's important. Now, sometimes you'll have somebody who's 55 who might be married to somebody younger. You need to factor that in, right? Are we going to prohibit somebody who's 55, 65, 75, 85 if they have a younger spouse? Have you factored that in? Is 45 an appropriate age? How are you going to handle grandfathering the people that may already have their grandkids or adult children living there? That's all going to need to be discussed before any sort of an amendment can be passed. Also, something to think about is sometimes you may have somebody who's 55 and over that has a child that's living with them that may have a disability. And they are protected under the Fair Housing Act to have somebody who might be under whatever age limitation you have in place. For example, let's say this passes and you have to have one resident that is at least 55 or over. Maybe they have a child that's 20 that has, a disability. And under the Fair Housing Act, we would have to make a reasonable accommodation and allow that person to have their younger disabled child live with them. So lots of issues on that one. That's a sticky wicket. So make sure you reach out to our firm to help you with that amendment and to talk through all the potential issues. And you need to have a PR campaign for this for sure. Because if you already have grandkids and others that have children, adult children living with them, there are going to be, some people that are going to be affected by this. And it's going to potentially be some heart-tearing stories, right? We want to make sure that they know that they're going to be grandfathered, and we'll probably have to have some paperwork that is recorded that reflects all that. So reach out to me and we can talk about how to best do that. Sorry for the long answer on that one, but that's a complex question. I want to make sure we covered everything. Okay, we're on question 12, and it looks like today we have about 32 questions. So we're about a third of the way through. In the summer of 2018, my HOA board consisted of 1 member. We originally had 9 members. Acting alone, this only board member voted to implement substantial changes to the landscape guidelines. Was this a legal action? Could or should the only board member have wielded this authority over the entire community? Well, what I would say is, okay, that's less than a quorum, obviously. So if you used to have a 9-member board, I'm guessing that your quorum would be 5. Maybe you have like a range of board members where you have to have, like, the lowest I've ever seen for board members is 3. So maybe if you had a range, they still would have had to have a second board member to do this. So, I really am calling into question whether or not those landscape guidelines that were adopted, wink, wink, are actually valid, because less than a quorum adopted it. So I'd like to take a closer look at that to see, what sort of authority you have to adopt landscaping guidelines. But on its face, based upon what you're telling me, this doesn't seem like a valid action. Next question is from a committee member. Does the order of candidates on a board election ballot need to be exactly the same for all the ballots? Random, alphabetized, reverse alphabetized? Okay, this is like interesting question day because I've never had this one before. Well, first, we'll take a look at our cheat sheet on how to conduct a successful annual meeting. We have it on our webpage under the cheat sheets tab on mulcahylawfirm.com. I have never actually heard of random, ballots. The first thing that pops into my mind, just selfishly, is I'm usually the one counting the ballots. And oh my gosh, what a nightmare would it be to be counting those with all those ballot names mixed up, because you get in a groove when you're counting ballots, especially if you've got like 4,000 or 5,000 ballots. You really do get in the groove, and it's more difficult to count if you're going to change up the order. So bottom line is, I've never heard of an association doing this, random, alphabetized, reverse alphabetized. What we typically see is an official ballot that's the same for everybody. Sometimes incumbents' names are listed first. Sometimes the ballots are alphabetical. It just really depends on what the board decides to do. Okay, next question from one of my favorite board members in Scottsdale. Thanks for being with us here today. Our CC&Rs do have a resident. Our CC&Rs have a resident named in. Our CC&Rs state that a resident named in a trust may run for the board. If the trust has a first mortgage and the trustee signed over the trust to a bank, and also the association has never received a directive stating a person has voting rights, just she is in the trust. Also was told anyone with a lawsuit against an association may not run either. What are some instances when board members may not be eligible? So these are all tough questions because I haven't seen the trust, but okay, here's the bottom line on who typically can run for the board. Number 1, look at your association's bylaws, because typically they will outline who is qualified and who is able to run for the board. So typically what we see is that you have to be a record owner to serve on the board. What does it mean to be a record owner? It means your name's on the deed. If a trust or a LLC or a corporation owns a property, typically a director, a member, or anybody who's associated with the trust, like as a trustee, would be able to serve on the board. But again, I'd like to see the trust. Now, the fact that they signed over the trust to the bank, sometimes that's done to help manage. Maybe the trustee, maybe the person's elderly and they want to have things set up so that when they pass away, that there'll be a trustee that'll oversee the trust. Maybe if they have an incompetence or somebody that is going to be a beneficiary of the trust that's unable to manage the trust in the future. So just keep in mind, just because they've signed it over to the bank, it doesn't necessarily mean that they don't still have the right to serve on the board. So I'd like to look at the trust, ask some questions about the trust to the person that's named in the trust to find out more information about it. But I would guess, honestly, if I had to guess here, I would say they probably will be qualified. What about somebody who's in a lawsuit against the association? There's really nothing that prohibits somebody who's involved in a lawsuit against the association from being on the board. Sometimes we'll see bylaws that say that if an owner owes money to the association, that they can't serve on the board, or if they have a violation on their lot, that they can't serve on the board. Be really careful if you're going to axe somebody from being on the board in those two situations, because you want to make sure that we're on strong legal ground that it is in fact a violation and that they do in fact owe money. If they get elected to the board, that's kind of a separate issue. If they're involved in a lawsuit, we'll have to be really careful to put a wall around them on any discussions pertaining to the lawsuit, and they wouldn't be privy to any settlement discussions, anything pertaining to the lawsuit, they would be walled off from, so to speak. So I think I've gone over basically all the instances when somebody can't serve on the board. Before you make that determination, like if somebody throws their name in the ring to run for the board and you're thinking about not letting them, be sure to reach out to your attorney to talk about it, because that most certainly is going to result in somebody being agitated and upset. You want to make sure that you're on strong legal ground. Okay, next question, question 15. We have an owner-occupied house who for the last 3 or 4 months has been observed to be harboring transients, and we feel also selling drugs out of the house. So far, we have been in touch with the daughter of the owner to stop this behavior, to no avail. We have contacted the police, who to date have done nothing to help. We have a good timeline in events at the house. We've levied fines for HOA infractions. What else can we legally do? I would definitely, in this circumstance, I would definitely go down to your police precinct and talk to the police about the situation. I think that, the police, their hands are kind of tied because they have to see, a violation of the law before they can really arrest anybody or take any action. But I think you need to get this house on their radar. They need to be doing more drive-bys. You need to have whoever is, a neighbor is witnessing this to keep detailed notes, take photographs of anything that seems out of the ordinary. Also, if we have enough evidence, our firm could send a letter to the owner, asking some questions regarding potential illegal behavior or, potential illegal activities being run out of the house. But really, I can't even do that unless we have really good evidence that there's problems. The sad situation on this, and we've been through this before, is, having transients there and selling drugs out of the house. It's so hard to prove. And unfortunately, what typically happens is there's an event, something happens that's bad, like a SWAT team comes in, or, I hate to even say this out loud, but there's like a drive-by shooting or something, and that really calls the issue to a head. And then the police obviously they're on their radar then. So I would just say continue to document. I would say continue to reach out to the daughter to see if they can provide help to you, but be careful that you're not accusing them of something that we don't really have proof of to the daughter. But based upon what you're saying, I'm assuming the daughter probably already knows that this is a problem. And have your attorney get involved and look at the situation. Keep talking to the police. Regular police contact about this is going to get this home on the radar of the police. So hopefully we can help you with that if you reach out to us. Next question from an owner. We have an architectural review manual that defines that the decorative gravel for all 674 homes must be desert gold. Has been that way since the declarant first formed the association 20 years ago. Common areas are desert gold. Declarant wanted any trails defined in red decorative gravel. Recently, one homeowner did their front and side yards in red decorative gravel. I'm laughing because I can see how that is just standing out like a sore thumb. Okay, the contractor was someone who's on the A.R.C. Oh my gosh, the facts are just getting better and better on this one. This person should have known better. The owner was cited and is now appealing for a variance. If the board grants a variance, do they have to do that for any other owner who wants any other color? So answer to that, short answer would be no. Just because you grant variance on one doesn't mean that you have to do it going forward. You also don't have to grant the variance. If you want it to be desert gold, you could require that person to, take that out and put in the right, color desert, take out the red and put in the desert gold. I see some problems here though. What if the contractor who's on the A.R.C. gave them tacit approval? And I mean, kind of, they didn't tell them that, right? That they're going to argue that, well, this person on the D.R.C. told me I could do it, or the A.R.C. told me I could do it. So I do see a lot of little problems coming down the road if you make them change it back to desert gold. So if you ultimately determine that, you are going to allow it, make sure that you have a couple things in place. Make sure that you let them know that if it needs to be changed out in the future, it needs to go back to desert gold. You might even want to add in that when they sell their property, it has to be changed back to desert gold, and then record that with the recorder's office so a title company picks that up, and it has to be done before the close of escrow. Anyways, that's a sticky wicket, difficult problem. And I wish you the best of luck with that. We're here to help if you have any issues, but if you grant that variance, it's not going to make you do that variance for any other owner. But I will tell you this, it's going to cause problems for you because other people are going to look at that lot and say, I want that red. So it's, like I said, it's a sticky wicket. Question 17 from a board member. Since COVID, our community has had an increase in residents getting dogs, along with increased pet waste. Also, we've had an increase of residents getting roommates with increased vehicles on the streets. Is it reasonable to require residents to register their dogs, providing the dog's name, age, sex, and breed, along with all residents providing the make, model, color, plate, number, and year of the vehicle? Okay, great questions. I was one of those people. Actually, I was actually a trendsetter. I got my dog before the pandemic. I got our dog in October 2019. But I agree, almost everybody I know has a dog now. So we're getting a lot of problems from associations on how to deal with pet problems. We have a great cheat sheet that we actually put out before the pandemic, but we update every year, called Everything You Need to Know About Pets in Your Community Association. That's a great resource for you to take a peek at, just give you some tips on how to deal with how to stop the barking and people that don't pick up after their dogs, etc. So the question is, can we require residents, or is it reasonable for us to require residents to register their dog's name, age, sex, and breed? It'd be unusual. I don't have any associations, that do that right now. I mean, I guess, how is that going to, whenever I look at a question like this, where we're going to make the homeowners do something, why are we making them do it? And what purpose does it serve? We have to answer those questions. If there is a legitimate purpose, it really would need to be something that would be put in the CC&Rs that they would be required to do. So we're going to need to amend the CC&Rs. Same thing about the make, model, color, plate, and number and year of the vehicle. If you're going to make an owner do that for a guest in their home, that's going to need to be something that we're going to have a legitimate purpose for it. Like I said, ask why. I'm guessing it's because you want to know whose car is parking on the streets in violation. If it's a rental thing, rental, sometimes you're not allowed to do that in associations based upon your documents, like it's single family use. And if they're renting a room, that may not be something that's even allowed in your association documents. Hard to prove. If they say it's a friend that's staying with them, it's going to be hard to prove that it's actually a roommate. But you might want to reach out to the people that have these vehicles that are in violation and remind them of the parking rules and, start citing them for violations of parking their vehicles on the streets in violation. Now, in terms of, people not picking up after their pet waste, one thing I can tell you for sure is that people who have pets who are responsible, they notice the people who have pets who are not responsible. And so I'm pretty sure if you have a pet waste problem, if you start asking people whose dog is doing that or who's not picking up after their dog, everybody will be readily available to tell you who that person is. And if you have witnesses, you can send a letter to the dog owner, telling them that they'll be fined if they don't pick up after their dog waste. Okay, so next question is from a board member. Our HOA is seeking guidance on handling the verification and deposit of cash received from fundraising events that benefit community resources and services. Okay, so apparently your association is doing some fundraising. I'm not sure if it's if you're going to do it as a group that's part of your association, or if it's actually the board that's running it, or a committee, or sometimes we have bridge groups, or, some associations have like knitting clubs or bridge, all different types of groups. So I have to hear a little bit more about who's doing the fundraising. I would talk to your CPA because I don't know what kind of dollar amounts you're doing. Typically fundraising is small dollar amounts, but I talk to your CPA in terms of how is this going to affect our nonprofit status, and how do we, place this on the books as income? Is it something that we're going to do the fundraising and then just spend it right away? Is the fundraising like bingo or like a poker night or gambling night where there could be like some potential issues with ATF because you have to, be registered as, to do gambling on your association's property. It's really hard for me to give guidance without knowing exactly what's happening. But you're only asking for how to handle verification and deposit of cash received. So I would just ask whoever is handling the fundraiser to provide written documentation. If it's all cash, then it's going to have to be what was the fundraiser? So they should write up a report. What was the fundraiser? When was it? How long did it go? How much money did you get in? And have them provide an accounting and provide the money to you within a short time period after the fundraiser. Next question. We are a planned community with 7 board members. On the advice of our property manager, the Architectural Landscaping Committee was established with 4 members, all who happen to be board members. Property manager states having 4 board members, which is a quorum, on the ALC is not a violation of open meeting statutes. Please confirm if the property manager is correct or if there is an open meeting exception for committee functions. Okay, so a couple points. Number 1, under Arizona law, at least 1 board member must serve on the architectural committee. And that board member must serve as its chair. So, we need to just tick that box right off the get-go. We have a great cheat sheet on committees that we just shared with you. You can find it on our webpage at mulcahylawfirm.com under the cheat sheets tab. I don't agree with your manager. If a quorum of the board is discussing association business, this is an open meeting and you need to properly notice it as an open meeting. What I would do is if you have 4 board members that are meeting to discuss architectural violations, you should put out a notice to the community that this is an ALC meeting. We are noticing it because a quorum of the board will be present and we are required under Arizona law to notice this meeting as a board meeting because a quorum of the board will be there. You can put an asterisk there and say that no official board business will be discussed, only ALC business will be discussed during that meeting. A way around that would be to have your ARC only be 3 members, right? And have it not regularly scheduled meetings, because if you have a regularly scheduled committee meeting, it needs to be in compliance with the open meeting law. Okay, we are on question 20 and we have 33 questions, so 13 more to go. If a ballot contains 2 separate articles, can one be closed on the expiration date and time and the other article extended? Also, if a membership was notified on an expiration date, is the ballot still open? Okay, so great questions. Sometimes we see on ballots different issues, like one might be election of directors, and there also might be one that talks about a CC&R amendment or a bylaw amendment, and one may be to increase the special assessment and then elect directors. Sometimes the ballot does have different things on them, and so in some circumstances, the ballot can be extended beyond the due date, especially when you have two different requirements for something. Like sometimes the bylaw amendment might be significantly shorter, or a smaller number to pass, and the CC&R amendment might be a higher number to pass, and it's going to take a longer time. So we regularly see boards extending, measures to amend CC&Rs, to amend bylaws, because oftentimes it takes longer than they think it's going to be. And maybe there have been some delays with, COVID or the mail or whatever. So that is something that we see from time to time. If there was an expiration date on the ballot, as long as the board is communicating to the members, hey, we are, going to be extending the CC&R vote or the vote to amend the bylaws to a longer period, that's fine, as long as they're communicating it to the members. The one thing that can't be extended, I would say, is like if you have a ballot with election of directors and the annual meeting is the election of directors, we can't conduct the annual meeting and then say, we're going to extend the ballots and continue to accept ballots after the annual meeting, because the annual meeting is the time to actually elect the directors. So, that's an important distinction to note. Next question. If an owner is in violation of our CC&Rs and has been served a notice that he's in violation and asked to fix but refuses to do so, what does the association need to do to enforce a fine or several fine until he complies? This owner has put up things on his exterior of the building and will not remove them. We sent him notice that he's in violation, that he could request a hearing and timeframe to do so. He actually responded by filing with the ADRE saying we were illegally in office and wants us out. Gosh, sounds like a great friendly neighbor. The administrative law judge ruled that we could not be removed, but he says he's not going to do anything that we ask him to do. Okay, so dial into our enforcement of governing documents cheat sheet. So what do we do with somebody who refuses to, comply with the association's documents? I guess I want to see the pictures of what he's putting up on the building. I don't know if this is a condo, maybe if it's a common area, you might just be able to remove it after giving him notice. If it's his own limited common element area or it's a planned community, obviously I wouldn't remove it. I think what I would do in this circumstance is, looks like the fines aren't working. So I think you need to escalate it to your association's attorney to talk through what the different options are. You've already had good luck in the ADRE. Maybe you take them back there, have the ADRE rule it. Maybe consider filing a lawsuit, have the attorney call him or her, have the attorney write a demand letter threatening, to go file a lawsuit. I think it's not going to work with this owner. Obviously, he's litigious and, he's not going to pay the fine. So I think you need to escalate this one. Next question from one of my all-time favorite board members in Phoenix. Our 50-plus-year-old community in Central Phoenix has run into some property boundary areas within our community, surrounded on three sides with alleyways behind the homes and one stretch that borders on a city street. All of these have been assumed to be HOA common area based upon knowledge passed on by previous owners through the sales of units. However, there is no definitive documentation we can find in HOA, city, or county records that defines it. We'd like to resolve the ownership question once and for all. What is the best course of action that you would recommend for us to do? Well, you're probably not going to like this, but if you want to establish ownership, who owns what, you want to look at the plat. Is the plat definitive to let us know where the property lines are? Can we see on the plat, the property lines? You can also go to the assessor's office and do a view, pictometry view. However, those are kind of tricky, especially if the alleyway in your case would be, not a large area, like, let's say maybe 6 feet, 10 feet. Sometimes those aerial views on the assessor's office are off just a little bit, so it might give you a false sense of ownership or non-ownership. Really, the only way you can definitively know if something is your property or not is to have it staked. Hire a land surveyor, have them come out and stake it. Before you do that, you may want to check to see if there are any stakes already in the ground, because that would really help you determine where your property line ends and where the neighboring owner's property line begins. So I hope that helps you with that subject. Reach out to our firm if you need any help with finding a surveyor or if you have any follow-up questions. Next question, we are considering establishing a permanent email address for board members in our HOA, such as like president@hoa.org, etc. These could be used by current and future board members. Do you see any issues with this? Our thinking is that this would be a best practice for preserving HOA records over the years. Do you think that this is a good idea? Actually, yeah, I do think this is something I would not be opposed to. If your association wants to do something like this, I think that's a great idea. Next question. The CC&Rs committee needs some clarification on the articles of incorporation. Can we just include the manual for owners, a copy of the certificate of incorporation that's filed annually instead of the outdated articles of incorporation? These original articles add nothing informative to the manual and cite people who are long gone as statutory agent. Of course, the original would be kept, just not distributed. So I'm not really sure. So you have a CC&Rs committee. Apparently you're putting together a booklet for your owners of important documents. If you are providing, important documents to the community, I mean, it's really not necessary to provide the articles truthfully, and it's not necessary to provide the certificate of incorporation or the annual report that you file. The most important things to give the homeowners would be the CC&Rs, the bylaws, the rules, architectural guidelines, if you have any fine schedules. In my opinion, that would be the most important thing. And really, you could just put all this online, and they can pick and choose on the website for the association what it is they want to see. Now, if you're disclosing records to a buyer, I think you should provide the full copy of the articles of incorporation to the buyer in the disclosure package. Okay, next question, question 25. Our association board is small and somewhat casual. Our front steel screen security doors have apparently never been regulated by the architectural committee. And now we want to standardize at least the color going forward, grandfathering current ones in. Can we add this to the rules and regulations and remind homeowners that any changes must be approved? It would be kind of unusual to add this to the rules. I'd have to see how broad your rulemaking authority is in the bylaws. I think maybe what I would do is just communicate to the owners regularly that they need to get approval prior to making any changes to security doors. Talk about it at the annual meeting, put it in your newsletters, talk about it at regular board meetings. This would be something that would be more likely to be placed in design guidelines, design like architectural guidelines or design guidelines if you have those. If you don't, I suppose you could add it, just to the rules and regulations, a reminder that people need to, submit architectural applications for any changes to their property pursuant to your CC&Rs, whatever it says. But it would be kind of unusual to put that in the rules. So just mentioning that if you have a bulletin board at your association, you also could put it up on the bulletin board. Okay, next question. We're on question number 26, and we have 33 total questions, so just a few more. Our board does not agree on the detail to be included in the minutes of executive meetings. Quite often, it's only a discussion, and there are no motions or votes. How much detail should executive session meeting minutes contain if this is the case? I would just state that the board discussed the issue and leave it at that. I am a big proponent of short meeting minutes. If there's a vote, obviously you have to have more information, like the motion, the second, the vote tally, and then what was ultimately decided by the vote. We also have a great cheat sheet, just on this topic called Community Association Board Meetings that talks about, what topics you can talk about during executive session and how to run an effective board meeting that might be helpful for your association or really anybody else who might be listening in here today. Okay, next question. Our board was unable to pass our budget for 2022 at our November meeting. We did an email vote with no notice to the homeowners. what would happen if the board did not pass in time to notify the homeowners for the January change in payment? Did the email vote require unanimous consent? How does the HOA fund it if the budget is not passed? So this is like a plethora of questions. Okay. So if you didn't pass it at the November meeting, you really could have had a December meeting to approve the budget. And the budget's kind of a serious, big issue for an association every year, especially because you're, changing the amount that's going to be owed in January. So if you had consulted with me, I would have suggested that you just have a quick Zoom meeting and notify the membership to approve the budget. It looks like you didn't do that. You instead had an email where you approved the budget by email. I don't really look favorably upon that unless it's an emergency circumstance. We aren't suggesting to our clients that they use email to approve anything. One exception would be, if the board can't meet in person and they can't meet on Zoom and there's truly an emergency that's occurring, we would allow an email vote for that. I don't necessarily think this is an emergency, although I don't know how long it takes to put the coupon books out or to notify the members. So not really feeling like this was an emergency situation, but it could have been. What I would recommend is at your next regular board meeting, you reaffirm the decision in the minutes so that there's a paper trail that, this was decided and the circumstances that required you to have an email vote on this. I know that there are a lot of management companies out there saying that it's okay to make decisions of the board by unanimous consent, in writing. Our firm is not one of the firms that agrees with that. There are 2 administrative law judge cases in Arizona that clearly state that boards need to be meeting, and properly notice meetings, complying with the open meeting laws when making decisions, and that these unanimous written consents are not valid. So be really careful on that going forward. How do we fund the budget if it didn't pass? Basically, what you do is just use the budget from the prior year and have that carry over into 2022. And then as soon as you can get it passed in 2022, then you just adopt the budget and, have whatever the new pay rate be effective then. Next question, our HOA is a 55 plus community. We verify the age of owners as they apply to purchase. The relevant information is collected on a form rather than keeping a copy of the document presented. The form includes the person's name, address, what type of proof was presented, the year of the person's birth, the date of collection, and who collected it. Is there anything else we should be aware of? I would also get a copy of whatever the proof is and put that in the file, number 1. And then remember, under the Fair Housing Act, we have to do a census on this every 2 years. So you should be following up and doing this as well every 2 years. Next question, question 29. Looks like we have about 1, 2, 3, 4, 5 more questions. When the HOA notifies a homeowner of the condition of the property, does the homeowner have to respond by registered mail, or does an email message suffice for the requirements as stated in 33-1803 paragraph D to apply? So 33-1803D went into effect, I don't know, maybe a decade ago, and we really hardly ever see owners using this as a method to get more information about their violation. But basically what it says is that if the association sends an owner a written violation, the owner, if they want more information about the violation, they have to provide a certified letter to the association. And then there's an obligation for the association to provide different categories of information, which is like what's been violated, the date the violation was observed, who observed the violation, what they must do to contest the violation. Now, just so you know, our firm, when we send out a violation letter, we already have this information in the violation letter so that we've already complied with the statute. And most management companies are already doing that too. So the statute doesn't really come into play. But how some owners see the statute is, it's kind of like a gotcha for the board. So basically what it is the board sends a violation letter and the owner sends back a certified letter under 33-1803. And then it obligates, the board within 10 business days of receiving that certified letter to provide these 4 categories of information. And there's obviously, you violate the statute if you don't, the association doesn't comply with that. But like I said, our firm, most association management companies, they're already complying with it in the first notice. So we don't have to comply with it if the owner does send a certified letter, just kind of like an extra little insulated layer in case there's some sort of mistake. And whoever opens the mail doesn't tell the association that a certified mail was sent. Okay, so can an email message suffice and require the association to provide these 4 categories of information? No. The way the statute is written is that the owner would have to provide a request by certified mail. Next question. There seems to be a race to see who can have the loudest vehicle. I woke up 4 times last night and this morning. Our streets are City of Phoenix owned. Is there anything the HOA can do? Well, you probably have a nuisance provision in your documents. And if you know who the perpetrator is, you can send them a letter for creating a nuisance based upon, the noise that their vehicle or muffler or whatever motorcycle is making. You also can put signs up in your community asking people to, keep the noise down. That's something that some associations do. They have like put up sandwich boards or talk about it at meetings or, put it in the newsletter, et cetera. Just communicating with the owners, the importance of, being quiet. Now, if the streets are City of Phoenix owned, and it's non-owners doing this, you can reach out to neighborhood services from the City of Phoenix and see if there's anything that they can do. I know that some communities will put up those large electronic signs saying, slow down or please keep the noise down. Maybe the City of Phoenix has a program like that where they might be able to help you out by putting up signs like that. Next question. A significant other of a homeowner is interested in running for the board. This person was told she could get a power of attorney or proxy from her boyfriend to run for the board. Our bylaws state nothing specific. Is this to be allowed? So generally speaking, no. A power of attorney or proxy does not give somebody the right to serve on the board. So that obviously the power of attorney or proxy would be from the owner to the girlfriend or whatever. So that's important to note that does not, even though the power of attorney has broad powers, one power that it cannot ever do is allow an owner to delegate their right to vote or their right to serve as a board member to a third party. However, the owner could, provide a notice, of a designated agent to the association. And that then if they do that in writing, the owner could designate the girlfriend to come to meetings and the girlfriend to talk at meetings on behalf of the owner. But that would be the limited extent of that. Now, who can serve on the board? You'll have to look at your bylaws. Typically, a record owner only can serve on the board. Sometimes, in rare circumstances, it does allow a spouse or a non-owner to serve on the board. But again, that's really limited. Usually it's owners only are allowed to serve on the board. So check your bylaws to see what your bylaws say about that. I'm pretty sure your bylaws will have something, a requirement in there on that. And if your board has any questions on it, you're welcome to reach out to our firm and we can help you navigate that. Also, just kind of a parting point on that, it's really not a good idea to have non-owners serving on your board. There are limited exceptions to that. I have seen, some non-owners been able to serve when their documents allow for that, and they have been good board members, but in most circumstances, I advise against that. Okay, last 3 questions. If we don't have a dollar amount for a violation, how do we decide how much? Okay, so you're talking about fines, I'm guessing, and you're trying to determine how much fine is enough, right? First, we got to look at the statute. The statute in Arizona under the Condominium Act and the Planned Communities Act says that fines must be reasonable. So and they don't tell us or define what reasonable is. So we're kind of left in the dark on that. I can tell you after 25 years experience, I can pretty much set a fine amount that's reasonable based upon the violation. So, you want to reach out to your trusted experts to get their opinions, such as your management company, your attorney. Some examples that I can give you, from being in the trenches would be Fines for short-term rentals, those can be a little bit higher because if they're violating your short-term rental provision in your documents, you want to make the fine about the amount that the market rate is for the rental. So that could be higher. If you've got like an RV violation, you want to make the fine high enough that it costs more to pay the fine than it would be to park the RV at RV World for the weekend, right? Trash cans, keep those low. Palm tree trimming, keep those, a little bit lower too. I mean, I had a case once many years ago where the association had like racked up like $5,000 in palm tree fines, and the judge really did not like that because, it was only like $50 to trim the palm trees. And the judge wanted to know why the association didn't just hire somebody to go in under the self-help provision and do it. So, I think it's on a case-by-case basis. You got to look at what the violation is and then determine, what was a reasonable fine. Architectural violations, talk with your attorney about fines for those because those are kind of tricky. Okay, next question, last two questions. Are there any specific Arizona regulations for HOA management monthly HOA fees, billing invoices? It appears that my HOA management company does not apply an account overpayment credit to next year's fees. Can I request an audit on my account and the entire community? Okay, a couple things. Number one, your association should be keeping, an accounting for every owner. You're entitled to see your accounting for your property. So you should make a request under the business records request to see an accounting of your records. You cannot request for an accounting of the other owners, their statement of accounts for their units or lots. That is not something you can do under the law. There is kind of a weird law that went into effect in January 1st, 2020. And basically, it requires associations, planned communities, that have, it's planned communities and condos actually. So if they have more than 50 lots and they have a property management company, the association has to provide a statement of account in lieu of a periodic payment book to the members with the same frequency that assessments are provided for in the declaration. So if you have a monthly assessment, your board should be providing that statement of account to you every month. Now, I don't know how often your assessments are collected. I say every month because most associations are every month. So there should be multiple ways that you should be getting your statement automatically right now. If you're one of those associations, that has more than 50 lots and you have a management company, you should be able to provide that. They should already be providing it to you without you even asking for it. How they apply the amounts, to your account, that's also covered under Arizona law. They have to apply it first to the principal and then, interest afterwards. I mean, I can't understand why they wouldn't credit that to next year's fees. I don't know. Are they like refunding you? I suppose that would be okay, but if it was designated that, how the money was to be credited on your check, they should be crediting it that way. And actually, I'm not really sure why you would have an overpayment on your account anyways. So that raises some questions in my mind. Okay, last question for our last First Friday of 2021. You have mentioned in past seminars the messy shell game that sometimes happens when a term is up for election. A switch to a position that was just elected the prior year. Our directors and officers and directors are elected to staggered terms. Can you clarify, please, is the person for a specific position up for election or is just the person? After the annual meeting vote, does the board redetermine board of directors roles? Thank you. Okay, so this is a complex question. So here's the easy answer, and then I'm going to give you the tough answer. So the easy answer is a person is elected to a term for their position. So I'm on my board right now. Thank goodness I'm only the vice president. I'm not the president anymore. And so I am elected to my board for a 3-year term. I have to double check. It's been going pretty well, so I haven't been checking on a daily basis recently, but I think my term is up in a year or 2 years. So my board position is, my term is, let's just say for lack of time, I think I have one more year. So I'm elected and my term stays with me, right? My term as the vice president of my community is annual. So every year after the annual meeting, we do a little shuffle and determine who's going to be the president, secretary, vice president, treasurer. So technically speaking, the person and the term for the board position, they stay together, right? So I stay with my term. Occasionally, there's this, it is kind of a weird shuffle that sometimes boards do, but they do it. I don't always agree with them doing it. It's not illegal, but it just kind of, it's a little unsavory when I see this happening, because it just shows that possibly the person doesn't feel confident enough that they're going to be reelected. So what they do, so let me give you an example. So with my example, I think I have 1 year left on my term, right? And let's say that we currently have a 5 board member board at my community. And let's say that one of our board members moves and sells their home, and they decide to, they leave the board because they're no longer qualified to be a board member. And that board member has a 3-year term because they were just elected at the annual meeting in December. And I look at my term and I think, I only have 1 year left. I'd really like to not have, my term anymore. I want to be on the board longer, says nobody ever. But let's just say this comes up. What technically could happen is that I could resign from the board, my term, 1 year term left. I could resign from the board, and then the board could reappoint me to the 3-year term for the vacancy that was just created. Now, I agree. This is, like I said, it always makes me a little uncomfortable when I see this happening because it's legal, but I'm kind of like, what is motivating that person to do that? It just is a big question mark in my mind. And so to answer your question, yes, that sometimes does happen. It's unusual and it raises questions in my mind. It's not illegal. Okay, so then let's give my example again. When my term is up in December of 2022, the board could either appoint somebody to serve my term out, which sometimes they do, or there's nobody filling that vacancy for that year. And then, at the next annual meeting, that person, is going to get elected for my old seat on the board for a 3-year term. Very confusing. I hope I explained that well. After the annual meeting, does the board redetermine the director's roles? Yes, there should be discussion. Sometimes it stays the same from the prior year. Sometimes it changes, but there should definitely be an annual discussion about who's who on the officers for your community. Okay, that's it. We made it through 2021. We did a lot of First Friday free call-ins. I think we had 11 throughout the year. We taught a lot of virtual classes, 12 virtual HOA neighborhood services, HOA academies. It's been a great year. Just as kind of some closing points for the end of 2021, it's been my pleasure to work with the neighborhood services departments from the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. Over the past year, planning these classes, these virtual neighborhood services, HOA Academy classes. We've been a great team. We've worked well together. I appreciate the partnership that you've had with our firm to provide free education to board members, owners, and managers in HOAs and condominiums over the past year. We've accomplished a lot. We've had over 40,000 views of our videos since the pandemic started, which is nothing short of amazing, truly. We've worked really hard together, and I just want to say thank you to the team. I'd also like to say thank you to my team. The Mulcahy Law Firm team has done an awesome job in helping with getting prepared for these classes, getting the word out about them, helping, organize the questions, getting all the platforms set up, coordinating with the neighborhood services departments. You've just done a great job. So special shout out, thank you to Morgan Aronimus from our firm, who is 5-star in every way, and also to Yvonne Barron, who has helped a lot throughout this year. So great to have such a wonderful team supporting me, and I appreciate you. So stay tuned. Our 2022 spring and summer schedule for our Neighborhood Services HOA Academy virtual is going to be coming out very, very soon. We've got the dates on our calendar. They're going to be the third Thursday of every month, same time as before, 11 a.m. to 12 a.m. And we're always going to have that free Q&A question time. We're just finalizing the topics now, so we'll be getting those out to you before the first of the year. And as always, we're going to continue in 2022 with our First Fridays virtual free call-in where we answer questions for free. So on behalf of everybody at Mulcahy Law Firm and on behalf of the neighborhood services departments from around the Valley, I'd just like to wish everybody very happy holidays. I hope you have a safe and happy holidays and a great new year. And we'll be seeing you again in 2022. So take care, everybody, and have a wonderful holiday season.